The CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk
Talks.
to me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that want it. They don't talk to me. They back that want it. They don't talk to me. They back that want it. They don't talk to me. They back that want it. They don't talk to me. They back.
Hello and welcome back to the CLS Talks. It's good to be back. Hopefully everybody enjoyed the new year and the break that we gave you. We thought we didn't want to fill your heads too much with legalese and that kind of thing over the Christmas period. So into February, I'm Lionel Coveney and Des Carty is with me as always. Des, how are you doing?
Great, I'm great, Lionel. Yourself?
Refreshed.
How are you after the break, as you said, you gave the listeners?
Yeah, well, I mean, I was itching to go, obviously, and
Yeah.
I just did some practice shows in the meantime,
Oh, did you?
which we won't air because I just can't stay away from microphones. But
Yeah.
I'm great. Really looking forward to this. We've lots of juicy and chunky material to get through in 2017.
Sure have. We did discuss what we're going to discuss today previously in another context, but I just want to also mention to the listeners we do have plans to do the Art of War as well.
Yeah, we've had a lot of good response when we suggested in previous episodes that we would do Sun Tzu's The Art of War,
Yeah.
and we've both had a bit of a refresher ourselves on it, and I can't wait for that one, quite frankly. There's so much in there that can be learned and applied to the law, I think.
Absolutely. I mean, I don't know how long ago it is that you've read Sun Tzu, probably 50 years ago, I'd say.
Oh, at least.
Looking at you.
Yeah.
It has been a while since I read it, but I think if you, this is to preempt, I suppose, when the listeners are tuned in to The Art of War. If you get the book now, there's loads of translations of it available on the internet anyway, The Art of War as a PDF. And I think we might put up a copy on the newly refreshed website we have anyway, so we'll direct people to that once it's up there. And I think to preempt the putting out the episodes on The Art of War, people should read it independent of what we say, because all we'll be doing is putting in our translation over The Art of War that has been translated from Chinese. I think it's Chinese, wasn't it? Chinese language it was written in. So all you'll be getting really is our interpretation of the translation of The Art of War, because obviously neither of us can speak the old form of Chinese that's required.
Well, speak for yourself. You don't know that I can't.
I don't. I withdraw that statement.
But yeah, there is a very strong legal application. So when we speak about the translation, that's exactly what we mean. We'll be applying it to the work that we do on this, both within and without this show.
Absolutely. Now, the other thing for our listeners to remember is that, again, it is our translation of what we see in front of us, and we'll be applying it to our own experiences. And as I said, if you read The Art of War, say a few years ago or even a few months ago, you'll find that a second reading of it will have a slightly different, there'll be different emphasis on different parts of it, and then when you read it the third time and fourth time, so again, it'll grow on you, and then you'll realise, well, some of the stuff, eventually you come to a point where most of the stuff that you're doing, you can refer back to The Art of War as having been part of The Art of War, which we were also discussing in another context earlier today in a private conversation. So in retrospect, you'll find as time goes on, The Art of War will sort of put itself into your head, and you'll be actively applying it without giving it too much of a second thought.
Yeah. No, it's very, very interesting, and it's really about battles, and that's what we're engaged in when we step inside court or receive a letter or a legal document or whatever it might be. It's a battle, and you've often said to me, it's all these small battles. You can lose a battle, but ultimately you can sometimes sacrifice a couple of pawns. So you could sacrifice a point within a legal context and lose that battle, or be perceived to have lost that battle, but it will help you with the war ultimately.
Yeah, well, again, going back directly relating, and we're mentioning this again because we're going to do the other defences that you've had in a case that you were involved in. And The Art of War isn't about destroying the enemy, it's capturing the enemy whole.
Yeah.
That doesn't mean you destroy them completely. It means that you get them to the point where they will concede if possible, and if possible they'll have to let you either escape or walk away from. So you're not out for devastation or destruction, you're out to capture, as they suggest, whole, which is what I think that means.
And I think the most successful war that can be won, that is one that's won with as little bloodshed as possible.
Absolutely,
And
yeah.
that's what it's all about.
And you'll come away better yourself for it, I think, as well.
Yeah.
Okay, well, we get into the set of other defences.
Yeah, and when we say other defences, we're talking about a case that we've previously discussed on 2 episodes of this show, which I was first-hand involved in. A little bit of background to the case. I was travelling along, minding my own business.
Or not travelling.
Or not travelling, as the case was.
Stationary.
I was actually stopped in traffic and approached, in very heavy traffic, and approached by a member of An Garda Síochána who came up and accused me of speaking on the mobile phone and having tax that was out of date as well. So
And not displaying tax.
not displaying tax, yeah. So over the course of about 2 years, it eventually went to court. And we've outlined the successful defence that I used in court. But I had prepared a number of other defences just in case, for some reason, that first defence didn't work.
Now, we're not giving away the story because obviously the 2 parts of the story are available on YouTube there.
Yeah, and most people will already have heard them. So we're expanding upon that.
Yeah. So in relation then again, and again, we'll talk more about this as we go on in terms of the art of war at a latter stage. But you, on the face of this case that you won it primarily on the smallest of perceivable things. It wasn't that you stuck a dagger into the head of the monster and killed it, or cut their head off or anything like that. It was basically you chipped away at something that was technically, on the face of it, minor, but you made that was perhaps perceivably the weakest link.
Exactly,
point in
and
time.
the issues that I was in court on foot of were never mentioned in court. It never got anywhere close.
You never
to
got
that.
into the real perceivable battle.
No, not at all.
Yeah.
Not at all.
So the minor battles, what we're saying, folks, is if you chip away at the smallest of things and don't stop chipping away at them, those minor little battles could potentially win you the war.
Exactly, yeah.
Okay, so I'll lead with this for the moment, if you don't mind, Lionel.
Yeah.
And your defence on this occasion that you perceivably won the case with, or weren't actually put to prison over.
Yeah, survived.
Your first defence was the non-delivery of alleged fixed charge notices. So will you give the listeners a brief of that, and then we'll get into the second potential defence and third potential defence that you could have had?
Yeah, well, for anybody who has received a fixed charge notice in the post, that's the first step that is taken by the Gardaí or whoever is trying to fine you. And the law states that you have to be given an opportunity to either pay the fine and admit to the charge, essentially, or not, and then go to court and have your day and battle them. So the Road Traffic Act, and I will go into a little bit of this, states, section 35(1), where a member of the Garda Síochána has reasonable grounds for believing that a fixed charge offence is being or has been committed by a person, which he appears to have believed in this case, A, if the member identifies the person, the member may serve or cause to be served personally or by post on the person a fixed charge notice. So that's what you receive in the post, the fine, as we normally call it. Or, number 2, a prosecution in respect of a fixed charge offence shall not be instituted unless a fixed charge notice in respect of the alleged offence has been served on the person concerned under this section and the person fails to pay the fixed charge in accordance with the notice. So what that's saying essentially is that you have to be served with this fixed charge notice, and then that gives you the opportunity to admit to it and pay and receive your fine, the medicine, or challenge it then in court.
Okay, that seems reasonable.
Yeah. So it continues then. Section 38 says that in a prosecution for a fixed charge offence, it shall be presumed until the contrary is shown that the relevant fixed charge notice, if being served by post, has been so served where there is proof of posting or delivery of the notice. Now, there's a point to note here. I didn't receive this fixed charge notice. So immediately, having read the relevant laws that we're all aware of now, I thought, well, okay, hang on a minute. The law is saying to me that I have to be given this opportunity, and I wasn't. So here's something I can hang my hat on. Now, the problem then that I thought I would have was, well, how do I prove? Because the law says I have to prove that I didn't receive something. How can you prove a negative? That's quite a difficult thing to do. So I went digging a little bit deeper, And I discovered that proof of delivery in law is the receipt that has been signed by the person that an item has been delivered to. The item was in a good and undamaged condition and the receiver has accepted this. It is usually signed by the person named on the address panel. So straight away I knew that, hang on a minute, I didn't sign for anything, I didn't receive anything. So in law, I can show, if I can get my hands on whatever is being relied upon in court by the Gardaí to prosecute me, I know that I didn't receive what's required here.
So there won't be a
so I can
signature.
show, yeah, exactly. So I can show them that that doesn't exist. So I can prove in law that that hasn't been received.
Yeah.
So what did I do next? I went back to the Gary Doyle order, which we talk about in pretty much every episode of this show. The Gary Doyle order, whereby you're entitled to receive all of the evidence that the prosecution...
Full disclosure, yeah.
Yeah, exactly. What they're relying on or may not be relying on in court.
Yeah.
So I wrote to the guard. I didn't actually. I went to court and I requested the Gary Doyle order. That was granted, and the guard then sent me the evidence that he was relying upon. So
Okay, just to codify that for the listeners. Right, so you you looked at the law in relation to the non-delivery of alleged fixed charge notices or thereabouts, and you decided that at that point in time, without having put together a cross-examination, you wanted the Gardaí to prove that they had actually delivered this fixed charge notice
Exactly.
as part of the full disclosure of whatever evidence that they were relying upon. And you wrote to the guards in the aftermath of seeking the Gary Doyle order, or did you not?
I did. I looked for the Gary Doyle order and that was granted, and they did send
Their evidence.
and I then wrote, the minute I got that evidence, I wrote to them and I said, look, is this everything you've got? You've another 7 days to provide me, otherwise it will be taken that there is no more evidence.
Okay, so they couldn't then, at that point in time, once you gave them that final opportunity to disclose whatever evidence they were relying upon, to then go laterally and lodge further evidence.
Yeah, exactly.
Unless they had an application in before the court to be able to lodge further evidence, because they were cutting you short then. If they came to court, it would be an attempt to rush to justice without full disclosure.
Yeah.
Okay, grand.
Which they didn't. They didn't. There was no extra
So
evidence.
the point here is that you were cutting them off and putting a line across, and I think we said this before anyway, which you were saying, right, I've accepted that this is your evidence. If you have any further evidence, I'm giving you another opportunity, a final opportunity within a period of time to disclose that evidence. If not, we're going to have to take it at this front. We're both in agreement that is your evidence.
Exactly. So to use a sporting analogy, the goalposts are now fixed and they can't be moved.
And with that then, they had not disclosed a fixed charge or a copy of registered post of delivery of the fixed charge notice.
No, there was nothing in there. I knew there wouldn't be.
So you knew the answer already.
Exactly, and I think that's very, very important. You've touched on something important. Never ask a question that you don't know the answer to in a legal context.
Correct. Well, look, we won't keep going on about this, because at the end of the day, the court did say, well, basically, if they can't prove delivery of this fixed charge notice, they haven't got a case, essentially. So we're going to dismiss this with prejudice.
I mean, I was slightly concerned that something could be manufactured. So that's why I had other defences ready, because I've been asked once or twice in the past, well, why did you bother getting the other defences ready if you knew that the law was on your side and you knew how to cross-examine? Well, things don't always go to plan, and I mean, if a guard is able to say that I was on a mobile phone when I wasn't, well, they're just as able to tell another lie, aren't they? So I wasn't going to just hang my hat on this and assume that everything would be done by the book.
And who's to say on the day they wouldn't have turned up in court with proof of the delivery of the fixed charge notice? Now, it's not that they should have, it's that they could have.
Yeah.
And then it'd be down to the courts to decide whether or not they'd allow that in as evidence. And more than likely, if the guard had turned up on the day with proof of the delivery of the fixed charge notice, the likelihood is, in my opinion, from what you've suggested, is that the judge would have allowed it in.
I think you're absolutely right, because when you examine the court transcript, and the case itself only took 4 or 5 minutes in the end, but when you examine the transcript, the judge gave the guard every opportunity, now with a smile on her face towards me, every opportunity to produce something in court that day. Oh, do you not have this? Do you not have that? Could you not show me this? Could you not show me that? And he couldn't, because he didn't have it. But what you say is absolutely correct. If he had a piece of paper in his hand and started waving it, I have no doubt that she would have accepted it.
Okay. Well, let's go on to defence 2. And this defence 2 that you had planned, which obviously we know now didn't happen.
Yeah.
It states here, unable to prove beyond all reasonable doubt. Now, if you don't mind me asking this, what does that mean? Unable to prove beyond all reasonable doubt.
The burden of proof in any criminal case is on the prosecution. These supposedly minor offences are criminal cases. Again, we've discussed that ad nauseum in previous episodes. So we're dealing with something that could potentially land me in jail. So
Yes,
it's a criminal offence, and the burden of proof lies with the prosecution. So what they have to do, they have to be able to demonstrate to the court beyond all reasonable doubt. So I mean, beyond any kind of doubt at all, that what they say is the absolute
100%.
truth. And they have to be, I mean, for reasonable doubt, you have to be able to demonstrate it with evidence.
We do tend to go off, listeners, on tangents here and there.
Yeah.
And myself and Lionel tend to discuss a lot of stuff outside of doing these talks anyway, as you might gather. So it raises a point for me that we discussed earlier today, which was this thing of the testing of what a criminal offence is. There is actually a test in law to define whether or not a criminal offence has potentially taken place.
Yeah.
And it harks back to 2 Latin terms. One is mens rea and the other one is actus reus. So that's mens rea and actus reus. Actus rea is the act, mens rea is the intent. So there's the act and the intent in translation to English. So for a crime as a test to have taken place, they have to prove that there was an intent to commit a crime and there was an act. The actual act took place, and both of them have to happen concurrently.
Yeah.
So, as we discussed earlier, unless you actually actively admit to the intent, first of all, and then to the crime, they cannot ever prove intent, at the very least.
Devil's advocate for a second. I'm listening casually and I'm thinking, but so what? Can you just go into court and say, oh, but I didn't mean to, it just happened by accident?
No, it's not that. You wouldn't turn it that way. You'd say, well, can the prosecution, per se, prove intention to commit a crime?
Yeah.
And secondly, what specifically is the crime? Now, crime in itself is defined as something whereby you hurt somebody, you damage somebody's property, or you steal something, primarily. There is obviously other bits and pieces to that as well, but that's broadly the basis for an actual act of a crime. But you cannot, unless the other party, say the accused, is actually says, well, I did intend, unless they come out and verbally say that, or they admit it in a statement, you can't prove somebody intended to do something. It's impossible unless you know their mind, and that's a thought crime then, isn't it?
Yeah, absolutely. And that's the really important thing to note for anybody who might be struggling to get their head around it. In a criminal case, you don't have to prove that you didn't do it. You don't have to prove that you didn't intend to do it. They have to prove
Both.
that you did, both at the same time.
Did intend and you did do it.
Yeah.
So they may even have a recording of the act, which probably and potentially could prove the act took place. But they cannot prove, unless you give evidence against yourself, the intent to commit a crime.
That makes sense then of why you're dragged into a police station and questioned for hour upon hour upon hour and pressure put upon you, because what they're trying to do is get you to admit guilt in one way or another.
Yeah, actively admit your own guilt in one way or another. Okay, so let's go back to the presumption. Well, that covers the presumption of innocence.
Yeah.
So then, following on from that, you have a couple of statements that obviously did the research in relation to Judge Hardiman, what he stated.
Yeah.
And will I read this out?
Yeah, go for it.
Okay, so Judge Hardiman in 2003, in the case the DPP versus the Department of Transport, DOT, stated, the presumption of innocence is a vital, constitutionally guaranteed right of a person accused in a criminal trial, and that the right has been expressly recognised in all of the major international human rights instruments currently in force. That's fairly heady statement to make. So he's saying that the presumption of innocence, we'll summarise it, is a constitutionally guaranteed right, and is a right guaranteed under the under the Convention of Human Rights, basically. And it's enshrined in that in force.
So in a legal sense, even if you're caught on camera stabbing somebody to death, until you have lost your case in court, you are innocent.
Correct. That's the ideal for it. So you have another, then you quoted an article here, 6.2 of the European Convention on Human Rights, states categorically that everyone charged with a criminal offence shall be presumed innocent until proven guilty according to law.
Yeah, and we're into another can of worms there, because it's the European Convention on Human Rights. It's another issue again, isn't it? But it says the same thing.
Well, given that primarily most charges that the state bring through the Gardaí or whatever it might be are actively construed in law or defined in law as being criminal offences, then I would argue that most of we call them, say, traffic offences. We won't go any broader than that. The traffic offences, basically, it could be argued from the outset that they are not criminal charges. If you take the stand and position of what it says in the European Convention on Human Rights, that you're presumed innocent until a crime has been proven.
Yeah.
That's it. But I'd always argue that traffic infringements, as I'd call them, are not criminal offences.
Yeah.
So, I mean, the only problem, of course, is you get the usual, the DBP, the state prosecutor, the state bar, the state solicitor, and the judges. They're all working for the same company.
Yeah.
So they're all actively, be it directly or indirectly or on the face of it, they seem like, sometimes the judges seem like they're not trying to engage you with this, but they are all actively working for the state, and therefore they're biased in terms of attempting to prosecute you criminally, but always actively seeking that you give evidence against yourself. That's the crux of this, folks.